And then this is a 15-minute round, as you know. I will be holding up the time cards, same as before, 10, 5, 1, 0. And then we do ask that we check your notes again, if you don't mind. Perfect. And then with that, I believe we're ready to proceed. So I will go grab the justices, bring them back, and we'll get started.
Sorry. Please please be seated. Please call the case.
All right. The California Court of Appeal is now in session. Chief Justice McKenna presiding alongside Associate Justices Lee and Jarvis. All persons having business before this honorable court are admonished to draw near and give their attention, for they shall be heard. God save the United States of America and this honorable court. The first case for argument today is Adele Ellis versus Balboa Miles. Yoni Hirschberg for appellant and Angela Rowe for appellee. You may be seated.
Could you state counsel's names for the record again?
It's Yoni Hirschberg for appellant. No. Are you not doing appellant?
Respondent.
Okay.
Yeah.
Can you guys flip, please? Oh, you're respondent.
Yes.
Okay. Angela Rowe for appellant.
Thank you.
And Yoni Hirschberg.
Thank you. Counsel, are you ready to proceed? All right, we'll start with the appellant. Ms. Rowe, please proceed.
Good afternoon, Chief Justice McKenna, Associate Justices. May it please the court. My name is Angela Rowe, and I represent the appellant, Ms. Adele Ellis. At this time, I would like to reserve 1 minute of rebuttal, please.
That's fine.
Thank you, Your Honor. Targeted speech used to mobilize others is not mere words. It constitutes the concrete steps that may amount to extreme and outrageous conduct. This court should reverse the lower court's decision for summary judgment for 2 reasons. First, because reasonable minds could differ as to whether Mr. Miles's conduct constituted a threat of physical harm, that is precisely why a jury should resolve this genuine dispute of material fact. And second, Mr. Miles abused a position of authority when he directed and commanded an engaged audience that led to the foreseeable risk of harm. With respect to my first point, Your Honor, a threat of physical harm arises from targeted conduct, which would lead a reasonable person to foresee a credible risk of harm.
But would you agree that Miles never made any threats of physical harm to Ms. Ellis?
I'm sorry, can you repeat the question, please?
Sorry. Wouldn't you agree that Mr. Miles did not make any threats of physical harm to Ms. Ellis?
Your Honor, he may not have made explicit direct threats. However, we view that the lower courts had a very narrow analysis because they focused on the absence of an explicit threat. But precedent has shown us and informed us that for a credible threat, explicit language of harm is not necessarily required. And we see that in Huntington Life Sciences versus Stop Huntington Animal Cruelty USA, where the 4th District California Court of Appeal held in 2005 that when the defendant directed targeted conduct specifically at the plaintiff by identifying the plaintiff's name, the plaintiff's location, and doing that in conjunction with endorsing civil disobedience, that this implied a physical threat. And so the court there did not require explicit language of physical harm. However, it was implied. And here we see the same thing, Your Honor, with Mr. Miles. He may not have explicitly stated physical harm at Ms. Ellis, but we see throughout his interviews, his general speech became more intense and specific, as we see in the record at 15 during his NPSC interview, where he identified Ms. Ellis by name. He identified her location of employment at Bolt X. And additionally, he stated that the building had inadequate security system.
But doesn't Cochran inform us that even conduct committed with an intent, which is tortious or even criminal, is insufficient?
Your Honor, that is correct. When we look to the conduct, they do look at whether it was intentful or whether there was recklessness. However, malicious purpose is not necessary, but we do look to the totality of the circumstances. And when we review this in context, we see that Mr. Miles used targeted words, whereas he started with things such as, let's show them we mean business, tell them what you think. In his interview at MPSE, he made statements such as, we must do everything to get the message across. They must not get away with this. You know where to find them. And so these words, although vague, he did not provide any discernible limits. He did not give any boundaries. And so it is unreasonable to think that millions of listeners watching the show, or even the 2 million social media followers that he has, that they would interpret this in one single harmless way. And so even though if Mr. Miles stated that his intent was for these fans to write letters or emails, he never specified that. He said we must do
Look at the totality of the circumstances, as you've suggested. Doesn't Urich kind of provide the gloss through the lens through which we have to review this, which cautions that the requirements of extreme and outrageous conduct is rigorous and therefore difficult to satisfy? Would you agree?
Yes, we do agree, Your Honor, and we're not trying to expand liability here. We actually give deference to the limiting principle that exists. We are merely requesting that that limiting principle be applied to the facts at bar. We are not trying to say that all social media or all public discourse should be policed. We focus on the conduct, as we always have with IIED.
But how does his conduct really exceed all possible bounds of decency? And how is it utterly intolerable in a civilized society?
Yes, certainly, Your Honor. When we look at the totality of the circumstances, Mr. Miles, he's very influential. He's an Olympic gold medalist. He has so many social media followers, so many fans, and for him to make these kind of statements identifying Ms. Ellis on national TV, mobilizing this large, massive audience. And we see in the record at 56, he stated that he knew that his fans would react angrily. And so by putting Ms. Ellis in this vulnerable position and exposing her to angry individuals, it's unreasonable that we would think that all of these individuals would not interpret his words as meaning that anything is possible, that even including physical harm. And so, Again, Your Honor, even when we look to Kiseski versus Carpenter's Trust, this court held in 1983 that the defendant's conduct was indeed extreme and outrageous. And there, when the
What were the facts of that case again?
Yes, Your Honor. There, the defendants, they worked with the plaintiff and they were coercing the plaintiff to re-sign the union agreement, and that if he didn't, that they would put him in the hospital, or that they would harm him, that they would harm his family, and they continued to threaten him and harass him for months, actually. And there, although the defendants personally did not carry out the threats themselves, the court held that the defendants created this climate of fear, and putting the plaintiff in a position of vulnerability. And
But wasn't the fear that there were threats that were made that if you don't do this, this bad thing is going to happen to you, right? Which is far different than what we have here.
Your Honor, that is certainly true. We don't have formal coercion per se, but when we again look to the context, Mr. Miles, he has this large influence, and when he's speaking to his audience and leaving Miss Ellis vulnerable, she stated to him, she texted him, record at 13, that she was feeling stressed and scared and afraid, and that there was vandalism on the walls. She tried calling him multiple times, but to no avail. He did not respond, and so she felt desperate, helpless, and vulnerable. So pressuring her into that position in order to get only the response that he wanted in nature is similar to coercion, and creating this environment of constant fear for Miss Ellis, that's a foreseeable
Are
risk.
we supposed to look at the results of his conduct in this appeal? Aren't we just dealing with whether or not his conduct was extreme and outrageous?
Most definitely, Your Honor. We're not trying to decide today a verdict. We are simply stating that a reasonable person may interpret Mr. Miles's conduct to be extreme and outrageous, and therefore there are competing inferences then if there is a possibility that indeed his conduct was extreme and outrageous, because then there is a tribal issue of fact here, and this is meant for a jury to resolve.
And isn't this more like the Mayweather case than the Kaziski case? Because in the latter, there were direct threats and promises of bodily harm if the contract wasn't signed. Whereas in Mayweather, I think the threats there were far worse than whatever's being implied here, yet that wasn't enough to meet the extreme and outrageous standard.
Indeed, Your Honor. And in Jackson versus Mayweather, which this court reviewed in 2017, they held that the defendant's online postings and radio interviews did not exceed all possible bounds of decency, and that his statements were mere insults. And the defendant and plaintiff there, they had formerly been in a romantic relationship. And so, although that is not a probative factor to this, they looked again to the totality of the circumstances, and they took into consideration the context. And there, the defendant's postings, it didn't mobilize any action. He wasn't requesting some kind of reaction from the audience. It was general public commentary there. And so that distinguishes from our case here at bar, which also leads me to my second point, Your Honor. Authority exists when individuals' position of power can reasonably affect another's interests. And
Wasn't Alice really the person in the position of authority over Miles? Because he had one of the most lucrative endorsement deals in the history of the company, and she would say things like, "Don't bite the hand that feeds you," and this could turn out really bad for you. So isn't she kind of the one in the position of authority?
Certainly, Your Honor. She does have formal authority here. She's a supervisor of Mr. Miles. However, that doesn't preclude the fact that he also had influence, and he had functional power. He had practical power. He had an influence that could overpower Miss Ellis and leaving her vulnerable. We look to a case like Bundren versus Superior Court, also held by this court in 1983, where they reversed summary judgment because they found the defendant to have extreme and outrageous conduct, and that was because the defendant acted outside their typical qualified privileges of a creditor.
But the patient there was in a very vulnerable state. You're not arguing that Miss Ellis was in somehow inherently vulnerable state, are you?
She wasn't inherently in a vulnerable state. However, Mr. Miles put her into a situation where she was almost defenseless because he has this influence over millions of individuals where she does not. She simply does not. And so when he's making these statements claiming that she manipulated him for corporate greed, then she doesn't have that same capacity to address the same crowd. And
Isn't that just him being bombastic, as is he's known for being kind of a showman. In fact, your client during her deposition described him as a showman. Wouldn't this be in line with cases like Urich, which just says, this is just how this person talks, and his audience would not construe that to mean, pick up pitchforks and go do harm to her?
most definitely, Your Honor. I think the distinguishing point here is that Mr. Miles's conduct as a whole reached that level of extreme and outrageous, whereas in Urich versus Superior Court, the defendant there, the conduct, it was just merely mild insults, as they said in the holding. And the defendant there, the context of the statements that he was making was outside of an employment environment. He was saying that she was senile because she's 40, and there was no actual reasonable foreseeable harm there. He wasn't using his supervisorial position to overpower her and use his authority over her.
You seem to be arguing that this was extreme and outrageous because he threatened her safety, and in the alternative, because he used a position of power to harm her interests. But the interests that we've talked about in the past are more in the line of financial interests, right? The interest here, you are again arguing safety interests. So can you use the position of power argument in this type of situation? Don't you actually have to prove that his words and conduct constituted a threat? Aren't we really going under the initial prong, the first prong of threat?
Your Honor, while that is true, however, peace of mind is a legally protected interest, and the harm that results is the type of harm that we are trying to prevent with the law of IIED. And therefore, although they are in a business relationship and there are financial outcomes or financial consequences from this, they had a close personal relationship before they worked together. And by him identifying her by name, resulting in a brick being thrown into her car, he almost set a very ripe foundation leading to foreseeable harm. And although we're not here to police poor judgment or bad behavior, the law does not tolerate conduct that exceeds all that is tolerated within a civilized society. And so, may I briefly conclude, Your Honor?
Yes, very briefly.
Thank you. Well, for all the foregoing reasons, we respectfully request that this court reverse the lower court's decision. Thank you, Your Honor.
Thank you. Mr. Hirschberg.
Good afternoon, Chief Justice McKenna, Associate Justices, may it please the court. My name is Yoni Hirschberg, and I represent Respondent Balboa Miles. Your Honors, the law should not intervene in a celebrity media dispute. This court should affirm the trial court's ruling because no reasonable jury could find that Mr. Miles' statements on TV constituted extreme and outrageous conduct. The California Supreme Court held in 2009 in Hughes v. Pear that extreme and outrageous conduct is conduct so extreme as to go beyond all bounds set in a civilized society. That is a very
Counsel,
high...
So we're looking for conduct, like you just said, that exceeds all bounds of decency in a civilized society. So who makes that decision? Who decides what the standards of decency are?
So this is an objective standard. So we would have to go based off this court's past precedents as to what that looks like. And there's really two areas we're looking at here. We're looking at the threat dimension. We're looking at the abuse of power dimension. For the threat dimension, no reasonable jury could find that Mr. Miles' statements constitute extreme and outrageous conduct in the threat world.
But counsel, I'm talking about, decency, of understanding what is decency within society. Who is going to make that decision?
So that decision is made either by the court or by a jury. The court's job is to filter out all those claims that could not reasonably be found to be beyond all bounds of reasonable behavior. And so what we're really arguing here today is that this is not a case where a reasonable jury could find that there was extreme and outrageous conduct.
Even though he directed his fans he told the fans where to find the building and the expensive cars and mentioned that the security system was poor. Why would he tell his fans that but for to go and take some type of retaliatory either property or physical damage?
So I would point you to this court's past precedent in Jackson v. Mayweather, which is a 2017 case out of the 2nd District, where we have very similar facts. We have Floyd Mayweather, who was significantly more famous at the time than Mr. Miles, and he is saying much worse things about his ex-fiancée than Mr. Miles is saying about Miss Ellis. And there the court held that that was not extreme and outrageous conduct. Those posts alone—
What year was that case?
That was 2017. It was a recent case. And that it probably gives us the best barometer of where society is based off of just in terms of the time. And so really what we're looking at is also a case much more close to the Cochran v. Cochran, which is a 1998 case out of the 2nd District, that precedent where the court held that a threat for a threat to be extreme and outrageous, it must be an actionable threat of physical violence or death. And when we look at the Cochran, anything that falls short of that is the venting of frustration.
What about the Huntington case? Because in that case, we also have very similar facts, right? Where that is the activist group publicly touted that the employee's security system was a joke, very similar to what Mr. Miles said here, and stating that thousands of activists knew where the plaintiff lived, and consequently her car was vandalized in much the similar fashion as Miss Alice's was.
Yes, Your Honor. So when we look at the Huntington case, in contrast to the Jackson case, there's one very clear difference that really determines a lot of this, which is the actionability. In the Huntington case, there was a very clear nexus between the brute posting and the actual activists on the ground. They were clearly reporting to each other, coordinating with each other. With the Mayweather case, the Jackson case, Floyd Mayweather, he's just putting it out there. He's just saying, hey, this is where she is. Here's what she's done. There was no nexus between him and the fans. There was no direct connection. Therefore, it was not actionable. Remember, Cochran teaches us that for a threat to be extremely outrageous, it must be actionable. And that's why the present case, Mr. Miles' case, is much more appropriately fitting into the Jackson precedent than it is to the Huntington precedent. And that really gets me to something that my friend across the aisle conceded, which was there was no formal coercion. And when we look at what a threat is at the end of the day, it is a conditional statement, right? Either you comply with my demand or something bad will happen to you. In this case, something like physical violence or death for it to be extremely outrageous. And if we want to look at an example of what that really looks like, I would point you to the Koseski versus Carpenters Trust for Southern California, which is a 1983 case out of the 2nd District as well. And then there you see what kind of threats actually constitute extreme outrageous conduct. You're looking at these like Tony Soprano style, like if you don't comply, if you don't sign this contract, you'll be in the hospital. Really unambiguous.
Counsel, can you agree that making somebody vulnerable to violence could be deemed outrageous?
No, Your Honor. One of the things we see throughout a lot of these precedent cases is an idea borrowed from the Second Restatement of Torts, which is that we live in a rough society, and plaintiffs have to harden themselves to a certain level of hurt. It's not enough just to be vulnerable. It has to be that Koseski precedent, that very clear, unambiguous, if you do not comply, there will be physical violence or death that will befall you. And that kind of gets to the second point, the abuse of power.
But your client said, you know where to find them. Look for the cars next to that dumpy old brown building at the end of Hussein Street. And then talked about the bad security system. You know where to find them. That is not saying write them letters, write them emails. That's saying go to them physically. How is that not outrageous and extreme?
So I would point you to Mr. Miles' deposition where he said he was surprised. He was taken aback that his fans would do this. That surprise indicates that he was not coordinating or—
His intent is really not at issue here. What we're talking about is what his words were and whether his words and conduct were extreme and outrageous. You know where to find them. How is that not extreme and outrageous?
So I would point to the Jackson precedent, which is the court's most recent precedent on this issue. He pointed out where his ex-fiancée was, and he said that she had done way worse things than Mr. Miles said about Miss Ellis. And those public statements were insufficient. And in the same case, we have like Adele Ellis, Miss Jackson was very afraid for her safety. She was vulnerable, but that was insufficient. That was not enough to cross that boundary. And this gets me into my second point, which is about the abuse of power. There was no abuse of power here. Mr. Miles neither occupied nor abused a position of power because he and Miss Ellis were equal bargaining partners. This was not, when you look at this court's past precedents on the abuse of power prong, we're looking for extremely steep vertical power discrepancies like you see between a physician and a patient, between an employer and an employee. What we see here is two co-equal bargaining participants. Miss Ellis was able to meet each one of Mr. Miles' escalations with one of her own. When you look at the record at page 7, 9, 11, 13, 15, 17, 25, she is responding with her own power as the chief marketing executive of BaltX. She has decades of experience negotiating with Olympic-level athletes, and she is much more familiar with the world of media than Mr. Miles, who is fundamentally a runner.
But she only had 500 Instagram followers. I mean, he has a much broader audience than does Miss Ellis, and he used that platform to incite his fans to take some sort of action, which could be construed as physical action. And if there is a possibility that you can construe it that way, wouldn't we allow the jury to make that determination as opposed to the court?
No, Your Honor. When we look at this court's past precedent in the Cochran v. Cochran and Jackson v. Mayweather, neither court even contemplated the celebrity status of their defendants, and they were significantly more famous at their time than Mr. Miles is. To say that just because he has 2 million followers, that constitutes a position of power akin to a doctor over a patient or an employer over an employee would flood this court. I know it's a hackneyed phrase, but it would open the floodgates to any time somebody sees their favorite celebrity post something and they want to read something into it to take some action, that would open up a claim. That would expose every celebrity essentially to almost unlimited liability for intentional infliction of emotional distress. And that goes precisely against the whole idea behind the tort, which is, again, going back to that second restatement, which is really what this court has drawn on in the past, which is we live in a rough society. No one is saying what Mr. Miles said was sophisticated.
Is that the kind of society we really want? When you look at Cochran and Mayflower, it seems that the courts there were addressing a situation when personal, intimate relationships went bad. That's not what we're talking about here. We're talking about a business relationship. Do we want a society in which a client can tell with a huge Instagram following can say, you know where to find them? They have a bad security system. How is that not a triable issue on extreme and outrageous conduct?
Well, Your Honor, it's not. And I'd point to a few things. One, they were also friends. They were very close friends, in fact.
But they were not an intimate relationship as in Cochran and Mayflower. It seems that is the distinguishing factor here. We're not talking about a relationship that went bad, a personal relationship that went bad.
So I would point you to this court's past precedent in Urich v. Superior Court, which is out of the 3rd District. That wasn't an intimate relationship either. That was a contractual relationship as employer-employee. And there the court found that even though there was very negative statements being said by this superior in a very mean way, that was insufficient. Language alone was insufficient. So I would point you to that precedent. I would also point to Hughes v. Pear, where we see a trustee relationship. Again, this is more in the world of business, handling finances. And the court there said, no, that his words were not extremely outrageous. And his words went far beyond anything that Mr. Miles said. We're seeing extremely disgusting, threatening coercive sexual behavior in Hughes v. Pear that we don't even see here. What we see here in the present case is two co-equal parties who have a business dispute over the direction of a sports branding, merchandising. And one side, Mr. Miles, he's frustrated because Adele Ellis and BaltX, they want to change his image. And that really matters to him. His authenticity really matters. It matters to his fans. It matters to the value of his...
So counsel, Can you agree with the court, however, that there is power? There is power when an individual has millions of people at their fingertips that they can just reach out to around the world and say, here they are, do this.
Yes, Your Honor. There's no doubt that Mr. Miles uses power. He uses power to leverage a business dispute. That is very different than a position of power that exists formally, which, again, my opponent conceded did not exist here between, say, a patient and a doctor, where one is completely at the mercy, right? When you're a patient under anesthetic on the table, you are uniquely vulnerable. And here we see a very different picture. Miss Ellis has decades of experience in the marketing world. She's a chief executive of a very large sports merchandising company. She had power here too, and she used her own power. She went on TV herself, just like Mr. Miles did. We're seeing a very horizontal power relationship, not the steep vertical power relationship that we see in So v. Shin, which is a 2013 case out of the Second District, or in Bundren v. Los Robles, which was, again, a very steep case. We're seeing, and that behavior is even worse, right? We're seeing a debt collector who knew this patient was just had a very difficult surgery, was still recovering, and said, okay, now is the time. I know they're vulnerable. Now I'm going to try to extract money from them. That's not what happened here. This is very different. Mr. Miles had no reason to understand Miss Ellis as anything other than a co-equal bargaining partner.
But those cases seem to have a really clear-cut relationship of power, right?
Yes.
But we don't really have that here, so why shouldn't this go to a jury?
So if this court holds that this can go to a jury, we basically invent a very novel power relationship that says any celebrity, just by the merits that they have a lot of followers, has a formal position of power akin to patient, doctor, or employer-employee. And that would, again, it's a hackneyed phrase, but it would open the floodgates. Anytime a celebrity does anything, somebody can point, and not just in the case of IAD, we think of all the other times that formal authority matters in the law. That is a massive expansion of the law there. And it would open up, again, not just IAD, but any sort of claim that involves a formal legal authority. A celebrity would become liable. And that is a very slippery slope to be on. And again, a few other things I would point you to that really matter here. When we look at URIC, one of the things the court really described was knowledge and familiarity of the supervised behavior. Miss Ellis knew that Mr. Miles was like this. She knew his personality. That's why she hired him. They were close friends. That familiarity means that this could not have been exceeded all bounds because it was within what she expected him to do.
But if your conduct, if Mr. Miles's conduct is not deemed actionable, wouldn't that empower other celebrities to attack others anytime a decision is made contrary to their wishes?
So I would say that it is a very, very high burden. It is conceivable that somebody could cross it if they say cross into the Koseski realm or the Huntington realm. But again, that's the whole point of this tort, is that it only deals with the most extreme conduct. And that's why, and no reasonable jury could find in this case that there was extreme outrageous conduct because, one, Mr. Miles did not make an actionable threat of physical violence or death, and two, he did not exploit a position of power because he neither occupied one nor did he abuse it.
Wasn't there a perception that he was in a position of power at a minimum when there's an effigy on the lawn and he's depicted as the big one and Miss Ellis is depicted as the little one and it says not for sale? I mean, is there a perceived power dynamic discrepancy?
No, Your Honor. We were looking at a very specific formal legal authority for this prong. And that's why this court should affirm the trial court's ruling that no reasonable jury could find that there was extreme outrageous conduct in Mr. Miles' statements. Thank you.
Thank you. Rebuttal, Ms. Rowe.
Thank you, Your Honor. Counsel for Respondent has shown concern for opening the floodgates. However, this overstates the issue because we're not asking for innovation in our jurisprudence. The doctrine remains the same. We're looking at the conduct and we're looking at the record before us. When Mr. Miles targeted an individual and mobilized action, which resulted in foreseeable harm, this is not the type of conduct that we want to tolerate in a civilized society. When we look to his vague statements that targeted Ms. Ellis, reasonable minds can differ as to whether this represented an actual threat of physical harm and abuse of authority. And so he may have done everything but thrown the bricks himself by laying out this ripe foundation for harm. And so we request that this case at least be reviewed by a jury because there is a genuine dispute of material fact. So for all these foregoing reasons, we respectfully request we respectfully request that the lower court reverse. Thank you, Your Honor.
Thank you. This court will take this matter under advisement. Thank you.
Thank
We will
you.
recess. And return with our decision.
We're going to Burbank.
Yes. We're going to Burbank.
Not again.
Shall we?
Yeah, sorry, I didn't want to run over your toes.
Congratulations, you two. That was awesome. That was so fun to watch.
How do you feel? How do you feel? I feel good. I'm going to appellate for. Nervous? Congratulations. I'm so proud of yourself. You're arguing at the Ninth Circuit. Congratulations.
Thank you.
Congratulations.
Thank you.
You had a good time up there?
It was a blast.
All right.
It was a blast.
You look like you're having
I
fun.
had a lot of fun. Thank you. Thank you.
great.
Thank you.
Are you busting out any stories while we read? Sure, you have a lot to share.
Who?
You.
No, I'm not. No stories.
No stories.
No stories.
How do you guys feel? What are the feelings?
It was fun.
Let's have a little therapy session now. All right.
But it was still scary.
Waiting for it is worse than once you
Then
actually
actually
get it.
doing it. Yeah, it's the waiting. I think a lot of the mooters would say the same thing about competition. It's the sitting and waiting for your round to start, and then you get up there and it's okay. You know what I mean? Yeah.
How did you come up there? Bring him up there. Go experience what it's like to be a lawyer.
They're shy, probably. Oh, yeah.
Is everybody going to the reception tonight? Go take a load off right now.
Yeah, for sure.
Have a little celebration.
Celebrate and then get right into finals.
Maybe take tomorrow. Celebrate tonight and tomorrow, and then go into
Sunday's a
finals.
day off.
Yeah. It's a day of rest.
More than enough.
She's all over. Just all over.
Oh yes, I heard.
Oh, last semester.
Second and third year.
Second and third.
Oh, okay.
Loosen it up a little bit, and then he has fun.
He's
Yeah.
amazing.
Yeah.
Such a great instructor.
Yeah.
Wait to see
Oh,
kids that you like pretend to.
Oh.
Keep the chat.
That's why you're all good right now until they come back. I'm good.
No, I'm in it.
Oh my god. Well, it should look like continue while you're like on, but still like.
I'm doing it.
You're a track switcher?
Yeah, I was in negotiations.
I was just negotiating.
So
So
was
yeah, who's your
I had Friedman, then Jarvis.
Okay, oh right.
Jarvis is great. She's really great. I'm glad she was here.
I'm sure she's very proud.
I hope so.
Congratulations. And to work on
Thank you. Thank you. Yeah. Sometimes what's funny is like you have all these arguments and then you go out the window and you're coming up with something new on the spot.
Yeah, did you find that you were doing that? Yeah.
You just see what's really existing. There's an opening. Alright, I need to avoid that. Here I can go.
And you manage your time so well.
Yeah. Always really cool. Instead of going up the again, give yourself like 3 to 15 seconds. Just like that. You can pick that up, like it sounds like.
And you're applying.
Absolutely.
The internet because when we expect anything, like moms to just come to the house and like say arguments or something. Also,
No, put it up there. It's in council. Yeah, council. Yeah, they can take issue there too. Exactly.
He was waving at the phone.
Oh yeah.
Oh no, I went to the concert in January. Yeah, they were in LA. I've seen them like 8 times. Oh yeah, I just lately I've been really into the SM art. They're so cute. Like they do something like Moot. I'm really into it. Yeah. Yes. Honestly, same. I tried listening to other stuff and I was like, also it's weird. It's not as good. Also weird like getting traditional. Like you're all like you're full like you know. It's so funny because I think it was part of your news. They had to stop midway because there's like the curfew. So they just all get up and leave. But I like, right? They're probably like old school or shiny and stuff. That's what I like. Yeah. Now I'm gonna watch it. Now that you mentioned that, I'm gonna look it up again. Oh my gosh.
Someone else. I'm like 17 in line. So like, let's take a break.
Yeah. This is all I need. Are you taking property now? No. Oh, so you're with Dolly right now. Oh, it's funny that you guys are like do like a lot of IA right now. Oh, that's so Oh yeah, it goes so fast. I was like, he was like getting into like analyzing yeah. I know it was like a very different vibe. Like, yeah, so yeah, that's very he's like, no, we gotta get to this. That's his thing. I was like, no, you're section C.
I was section C, yeah.
But I don't think they much.
Oh, yes, yes. Honestly, now you say that.
He got emotional and I was
Especially for some it's like nothing builds on each other now. It's just like here's like 20 claims, analyze them individually. Right, it's all right. So you're like, well, you guys, I guess you're figured out yeah, until they kind of get into and now we're here like, no, and now it's like, oh no, it's 2 weeks and yeah, spring goes first. It's such a place. And then finals ends, and law review, journal pick up, and it's like that, and you will pick up and so it just keeps on going. I think like when we applied, it was law review did their thing. I went to cover what that is.
I'm doing a lot of acting today. Just like.
Like serious face, like you're doing.
Sorry, I can't help but laugh. It's kind of silly. Like.
Repeat what you said.
All right, let's see. Targeted
Targeted statements do not equal conduct. They are the cement that leads to foreseeable. Oh.
I just wanted to say a couple words before I talk. I just want to say thank you all so much for being here. If we could please give a round of applause to our incredible advocates. Thank you so much for your participation, your dedication, your the process. It's so incredible to watch you all grow even throughout rounds. I also want to say thank you to, I know they're not here, but the court security staff, the Ninth Circuit staff as a whole. I also want to say thank you to Jordan Lee from Student Affairs, who's not here, and Darlene, Student Affairs, and Dean Mena. We would not be able to do any of this without them. And then also to our director, Professor Natalia. Thank you. Also a very important part of this process is having a director to lead you, so thank you. And then also, I just wanted to say a huge thank you to our esteemed justices. Thank you so much.
Oh,
for taking
thank
the
you.
time. Your time, your effort, your dedication to this program. Thank you. And with that, I'll pass it along to Christina Ramirez.
I'll be really quick, I promise. And I'm gonna come pretend like I'm arguing. So as everybody knows, we have three phenomenal judges up here, justices up here. We have Justice Lee from the Nevada Supreme Court. Please clap. We have Justice McKenna from the Hawaii Supreme Court. And we have the wonderful Professor DeJarfis from Southwestern Law School, who helped write this problem. And on behalf of the Moot Court Honors Program, we just want to thank you all for donating your time. And because you donated your time, we have donated on behalf of all of you. So for Justice Lee, we donated to the Girl Scouts of Southern Nevada in your honor. Justice McKenna, in your honor, we have donated to the Hawaii Food Bank.
Thank you.
And Professor DeJarfis, in yours and Samantha's honor, we have donated to the University of Michigan Bachelor of Theater Arts Program. So thank you, and you may now announce your winner.
I love that one. Thank you guys so much. That's awesome.
Thank you. So we'll provide some comments and then I'll announce the winner.
Gosh, I'm still moved by that. Phenomenal. You guys were absolutely phenomenal. Oh gosh, see.
She's a big crybaby. You want me to start?
Maybe like 5
Go
minutes
with
ago.
Justice Lee first.
She's already got me dialed in.
Yeah, big crybaby. No, I'm kidding. I cry all the time. I cry on the bench. I cry when I'm not on the bench.
No,
It's the whole thing.
I got this.
It's
I promise. I got this.
Okay.
Okay.
So amazing. I get the wonderful opportunity to, for years and years and years, see 1Ls grow through the process of coming in, big eyes that first day in laws, and you know, you have you go up to the front of the class and say your name, or not even necessarily in front of the class, but speak for the first time, and the anxiety, and it's so amazing. Think about where you were at day one and where you are today. We all talked about it. This was superb. It was absolutely brilliant. Kudos to all of you. You couldn't have done any better. So, Ms. Rowe, I mean, phenomenal. Your presentation, your speech, everything that you did up there was absolutely convincing, amazing deference to the bench. You knew your stuff inside and out. You were unflappable. So congratulations. You're amazing. Amazing. You knew those cases better than we knew those cases, I think, at times, and you know the facts and everything. You were very compelling, absolutely had us blown away. I mean, in some respects, you were in the tougher position and really rose to that challenge. So, excellent job. Thank you.
Justice Lee?
Yes, I associate myself with my colleague over here. I can't, you guys are 1Ls? That's amazing. That is just, I don't think I gained the oratory grace that you guys have in your first year until I was like in my third year of practice. And I know how nerve-wracking it can be, and you guys showed no fear. It's like you guys were seasoned pros. Again, yes, I agree that Ms. Rowe, you were unflappable, and I just like you're a very calm presence, and so there's some power in that reserve. Like we hang on to every word because you're not as gregarious in your presentation, which is powerful in and of itself. It's a very, very persuasive way to litigate. Whereas you, Jonah, you're the opposite, right? You're there, you're convincing. I have to say, when I came in after I read the problem, I thought you had the losing case. I was like, there's no way you were absolutely going to remand this and vacate the summary judgment. But as you were talking, you were convincing me. And I'm like, yeah, that totally makes sense. And they were throwing some pretty hard questions at you, and you rose to the challenge every single time. You thought on your feet, you pivoted quickly. I love that litigation style as well. I think I was more of a Yuri than a than a Roe when I was practicing, so I recognize that type of persuasive, just like it's an excitement, and it's like, and you're really trying to get your point across, which I thought you did beautifully, and you clearly knew your cases, and you were batting back all of the really hard questions, particularly from these two over here who gave you a really hard time, and I thought you did so well. So congratulations. By the way, I will say congratulations to the both of you. This was hard. I tried to sneak out and leave so I didn't have to be part of the decision-making process, because I was like, it's almost an impossible decision, but just know there's no losers here. I mean, you guys made it to the finals. You guys earned it, and clearly you guys have very bright futures, hopefully as litigators, because it would be a shame to waste this talent. So thank you.
Let me echo what my colleagues here said on the bench. Both of you were just excellent. And I think I've been doing this for about 10 years now, and I'm just never ceased to be amazed at how good you are. The 1Ls that come here for the final bench, it's just, every year is just incredible. And Professor Carpenter and Professor Talia, from the beginning, and this is Professor Talia's last year. Really going to miss her. But Southwestern, you have a great laws program, and thank you for a great problem this year. I thought the problem was really good because it just really allowed the advocates to advocate based on case law and based on policy or whatever, it was good. Both of you were excellent. Your style was more the calm appellate style. Your style is more I would love to see you in a trial court. You would
Yes,
do really
frightening.
well with a jury, I think, But both of you were just excellent. And let me tell you, there's really nothing to criticize. I mean, excellent. Both of you were just excellent. We had to choose a winner. I didn't want to. I wanted to walk out and
She tried to walk out,
I
too.
tried to walk out too. I said, "Do we have to choose a winner?" It's like virtually impossible
We
to
almost
choose a
staged
winner
a
here.
walkout. We did.
Yeah. But we were told that we had to choose a winner, and so today we have chosen Ms. Rowe as the winner. Congratulations. So if it's okay, we'd like to come down and take some photos with the contestants, and whoever else would like to join us for the photos.
Okay.
Yeah, so we can go down
This way?
Congratulations.
Send me photos?
Yes,
Or,
we always
okay,
do.
then
Yes.
Then I don't need my camera. Okay, how should we do
I have you in the middle, the justices in the middle.
I was like, oh, over here. It's like,
Right in the middle.
Okay, and
Angela on the other side.
and then the
Congratulations.
contestants.
That was very impressive.
Try to be as tight as possible.
Okay.
Like we all- there we go.
Okay.
We love each other.
Yes.
You have to get tighter.
If I was-
Okay.